Thank you for joining us today for a panel discussion on prosecuting sexual offences in Singapore, overcoming the challenge of gender stereotypes and prejudices. My name is Jacqueline Neo. I'm an associate professor at NUS Law, as well as the director of the Center for Asian Legal Studies, which is the proud organizer of today's seminar. So we're very privileged today to have a panel of esteemed speakers who bring with them a wealth of diverse experience and expertise on the subject of discussion. So first, we will hear from Mr. David Khoo, who is presently the Deputy Chief Prosecutor at the Attorney General's Chambers, where he oversees serious sexual offences, prosecutions of serious sexual offences in the High Court. He has some 20, 30 years of experience in criminal prosecution, so he will share with us some of his insights on the prosecution of sexual offences. Next, we will hear from Ms. Diana Ngiam, who is currently seconded to the Ministry of Law from Kwa, Wu and Palmer. Diana was an active member of the criminal bar and brings with her a wealth of experience in criminal defense work. Last but not least, we will hear from my brilliant colleague, Dr. Chia Wei Ling, whose research stands at the intersection of international and comparative criminal law. Well, one fun fact, before she joined NUS Law, she actually worked for the Interpol. So there will be some time for Q&A after the speakers share their insights. For those of us who are joining online, for those of you who are joining us online, please use the Q&A function on Zoom to ask your questions. As you can see, we have a panel with diverse experiences and backgrounds in the prosecutions and defense of sexual offences. And this is really one of the Center for Asian Legal Studies' aim to provide a platform for cross-academic and industry engagement in these important topics. Today's panel will no doubt provide us with much food for thought. But before we proceed, I wanted to make sort of a small word of care. As the panel discusses a specific area of crime involving sexual assault and other sexual offences, it may be difficult or distressing to some participants. And so I would like to apologize in advance if that is the case and ask that you practice self-care as you participate in the seminar. So without further ado, we will start with our first speaker, Mr. David Khoo.
Thank you, Jacqueline. First, I wish to thank the CALS for organizing this discussion and inviting me to be part of the panel discussion. All right, so I think I will jump straight into the topic. Right, prosecuting sexual offences, right, is not is a bit different from prosecuting other crimes. Prosecuting sexual offences, you often have to deal with a traumatized victim. So victim care is extremely important, right? In deciding whether to prosecute or not to prosecute, we, the prosecutors, and also the investigation officers, have to engage the victim. And there's a lot of care that we have to look out for the welfare of the victim. Okay? So that's the first point I want to make. Also, sexual offences often occur, right, in situations where objective evidence are not easily available, right? And even if you have objective evidence, right, for example, you find semen, right, on her body, the accused person often come back and say that the penetration was consensual, right? So in prosecuting sexual offences, very often it is word against word. The judge will, because it's a word against word type of scenario, the judge has no choice but to examine in great detail, right, the actions of the victim before, during, and after, right, the rape. And at times, the background of the victim will also be examined by the court, right, depending on whether it's relevant or not. So having that in mind, where it is a word against word type of situation, right, we, the prosecutors, must be alive and also must be acutely aware, right, of the stereotypes and the prejudices that may exist, right, when dealing with when examining the actions of the victim before, during, and after, right? So let me start with most common stereotype that all rapes must be violent, and because of that, the victim is expected to struggle. The victim is expected to run away, right, at the first opportunity and report the matter to the police immediately. Now, this is a myth. This is really a myth, all right? Our courts do recognize that this is an untrue stereotype, right? In the case of public prosecutor against GCK, the Court of Appeal went into some details into what is known as tonic immobility, right? When a person experiences fear, right, the body does not always react in the fight or flight type of situation. Right? In fact, there are 5 Fs: fight, flight, flop, friend, and freeze. Okay, freeze. Let me deal with freeze first. You know, when a person is faced with a traumatic situation, the person can just froze, and do not know what to do, and just remain silent, right? And there will be a lot of things that's going on in her mind. So that's why she didn't struggle, she didn't shout for help, because the mind is still processing what is going on, right? The next one is flop. Flop means a person will try to disassociate, right, herself from the situation, because it's so traumatizing that you try, the mind shuts down, right, and cannot process what is going on. And another one is friend. Some victims behave in a manner that they would try to befriend the perpetrator, right, in the hope that the perpetrator can then, you know, gain the trust of the perpetrator, and when there is a opportunity time for her to escape. Let me share with you. I've dealt with a case whereby the victim was raped by the accused, right, at knife point, right, and he was penetrating her, and it was a long time, right? It took a long time, like a good 15-20 minutes or whatever, right? And the victim then offered to fillet him, right, with the hope of him quickly finish off and then leave her alone so that she would escape. You see, so this is the type of reaction, right, from the victim. So it doesn't mean that she was not raped, right? She was raped. The accused person pleaded guilty in that case. Okay, so you cannot say that just because she offered to fillet him and therefore she must have consented to the initial penetration, right? So this type of myths, please, we at AGC, we don't subscribe to this type of myths. We will examine all the explanations that the victim could proffer to us, and then we'll present it to the court if there's a trial, right? So another stereotype that we, still on the expectation that the victim must always shout for help and report the matter immediately, and also struggle. We must know that in the context of Singapore, right, we see an increasing trend of intrafamilial cases. Right, intrafamilial cases. Perpetrator is known to the victim, right, often from the same family members. Right, it could be a cousin, it could be a brother, it could be a father, a stepfather, things like this. So in such a situation, you cannot expect the victim to behave behave in a way that as I've just described, that she would scream, shout for help, struggle, and all those. Very often you see that in this context, intrafamilial sexual abuse, right, there is this element of grooming. All right, the victim would have been conditioned from young, right? When usually the sexual abuse started when she was young, right? She'll be conditioned from that point onwards to accept that the rape is normal. It has been normalized. I've dealt with a case whereby the accused person pleaded guilty anyway. The victim behaved in such a way that whenever the perpetrator asked her to come to the room, inside the room, she would automatically disrobe, take out her clothes, because she wanted to get it over and done with. Okay, so that doesn't mean that why is she so cooperative with the victim? You have the stepfather in front of her, and the stepfather has been telling her since young that this is normal. This is a normal relationship between the father and the daughter, right? So that is a reaction. So please do not subscribe to this myth that all victims will definitely struggle and that all the rapes are violent, right? So there is no such thing, right? The next thing which I want to address is there is this expectation that victims should be able to remember every minute detail of what happened, right? So the victim has gone through a very traumatic experience, right? Right? It is not always that they can remember everything. As I've just said, part of the reaction of a victim could be flop, that is dissociate herself from the incident. The mind shuts off, right, and can't remember, and cannot remember, and would not be able to remember everything, right? Things like whether he used his right hand to do this or his left hand to do that, whether the accused took off her underwear first before he became naked, he himself took off his underwear, things like that. This type of sequence of which act happened first. Is the fellatio happen first, or is it a digital penetration happen next? Penile vaginal penetration happen after that. All these things, right? It is very often that they get mixed up, the situation, right? So I would, urge those people, all of us who are in the criminal justice system, be it investigating officers, prosecutors, defense counsel, or even judges, right? Those should realize that the victims very often cannot remember, right, all the minute details of what happened to them, right? So must look at her evidence and then weigh it, right, in totality against all other evidence, and then determine whether there is a ring of truth in what she has said, and do not just make a decision that just because she couldn't remember whether Act 1 happened first or Act 2 happened then, things like that, and they say that she has been inconsistent, and therefore she is lying, and therefore she could not be believed, right? So what I'm urging everyone to do is to look at the whole evidence and then come to a conclusion after analyzing each and every reaction of the victim, right? Next is this often, you often hear late reporting, right? Late reporting. Victims are expected to report the matter almost immediately or soon thereafter. In fact, we have cases whereby judges have held that, one judge even say that, he cannot understand why the victim didn't report to the authorities, right, when she had the opportunity to do so, right? So I would not go into the detail of that of that case, but anyway, we appealed against the acquittal. Court of Appeal upheld the acquittal, but on other grounds. But the fact that the late reporting and the effects of late reporting was not adopted by the Court of Appeal, right? It is a neutral factor, right? You still have to examine why the victim did not report the matter almost immediately, right? Now, let me quickly move on to this portion whereby, as prosecutors, we deal with a lot of representations being sent by defense counsel, right? Sometimes in the representations, right, they will exhibit some kind of prejudices. They ask us to take that into consideration, right? Which these cases may not eventually result in a court prosecution, right? Or maybe it's court prosecution, but they didn't advance this type of stereotypes thinking in court, right? But let me just tell you a few, right, of this. Previously, we often hear, a prejudice like, hey, the girl is wearing short skirt, she must be asking for it, right? Or why did she go into this secluded area, right? And she must have known that she can be attacked. Is she asking for it? Things like that. These are prejudice, but nowadays it's different. What type of prejudice? These are thinking that we do. For one, we do know that nowadays there are a lot of dating apps, right? Okay, Cupid. I don't know. I don't go to the apps. Can you give me some? Tinder. What bagel meets coffee, coffee meets bagel. I don't know what is that. Right? So they have all these type of things. So a lot of youngsters all participate in this, or they register, and then they fix dates. Sometimes that doesn't mean that they're looking for sex. That doesn't mean that they're asking to be raped. Okay, so sometimes people go to the perpetrator's house to meet, because there may be many reasons why they do so, right? So it has been cited that look at the girl, she had done this, and therefore she must have known that it will result in sexual intercourse, and therefore when it happened, it must be consensual. You say it's not that easy. This is a very stereotype. You cannot do that. You still have to examine what actually happened, right? What was the prearranged plan, and how come he actually ended up in her bed, in his bed, things like that. So there is no straight away you conclude she actively participated in this website, and therefore she's asking for it, and therefore she must have consented, right? Another one is that drinking. the victim went out with a group of boys to drink. Okay, now that end up being gang rape, right? That doesn't mean that she's asking for it and that she agreed to have group sex with these people, right? You have to examine. You cannot say that just because she was like she went there and she must have known that this is going to happen and therefore it happened. She must have consented to it. So we don't subscribe to such thinking, right? Another current trend that we see during representations, we can see that accused person through their counsel submit a lot of photographs, videos of the victim, right? That they have posted on the social media. Some of them, some of the materials show that she's very sexily clad, and or whatever Insta story or whatever that they have posted about certain things, and therefore they try to persuade us to say that this girl is a loose girl. She must have what called bait the accused person and things like this, and would have agreed to have sex with casual sex with the accused person, and therefore she was not raped. Things like this. So when we look at this, it is something that we have to examine, and then we have to ask the victim and all those things, and we don't subscribe to this belief, right? We will still ask we still examine the facts of the case. Last one, sex workers cannot be raped. We have a few cases, some concluded, some are still ongoing, right? Where sex workers were raped, right? So the fact that she is a sex worker doesn't mean that she cannot be raped. It's very clear, right? So there is no such thinking that she wouldn't mind being raped. Therefore, she didn't get payment automatically. She didn't get a payment, and therefore she cried rape or things like this. So we have to examine the facts, see whether rape is made out, and then we, in appropriate cases, we will tender charges against the accused person. Right. I will end by saying this. Prosecuting sexual offences is really not simple. Right. It is not easy to get a conviction if the case hinges on the evidence of the victim alone, right? Often the court has no choice, right? Often the court has no choice but to examine in detail the behavior of the victim, determine whether there is any truth in it or not. Okay, so sometimes it will result in acquittal, right? When it results in acquittal, it does not necessarily mean that the victim had lied in court. Please, it does not mean that. Okay, it simply means that the prosecution has failed to prove the case beyond a reasonable doubt, and the judge has found it unsafe to convict on the evidence. Right? This is the part of the system. It shows that the system works. Can you imagine you living in a state whereby all sexual offences of prosecution result in conviction? Right? Would you want to live in such a country? Right? It shows that our system is our criminal standard of proof is beyond a reasonable doubt. So, in a word against word case, a case of word against word, it is difficult, right, to achieve that, right? So if there's any acquittal, please, it's not because the girl has lied. It simply means prosecution unable to prove this case. Right. Okay, so that's my comments. Right, thank you.
Thank you. Thank you very much, Mr. Koh. Thank you. So I think that's given us quite a lot to think about, and but before we go into discussion, we'll hear from Mr. Anangyam.
Hi, everyone. Maybe I can start by saying that I'm confident that none of those representations came from us. I think as a defense counsel, and maybe the benefit I get from being a female defense lawyer is that I shy away, thankfully, from the stereotypes that David has spoken about. And I think that informs the way we approach cases and represent accused persons, because we end up testing the evidence a lot more, bearing in mind certain stereotypes that others may have, right? I say this because in cross-examination of alleged victims, I like to say alleged because there's always the presumption of innocence. But yeah, when we cross-examine alleged victims of sexual offences, we are very careful not to ask questions that intimate the very stereotypes that David spoke about. Because number one, it looks bad on us, but more importantly, it brings us nowhere. Maybe I can deal with, so largely I agree with whatever David has spoken about, but maybe what I can do is share with you two category of cases, and then I go into the various stereotypes that tend to happen. So one large category of rape offences that I've dealt with, I don't have as many years of experience as David, of course. I've only been in practice for about 10 years or so, much younger. Still learning. But yeah, so the one big category of rape offences that we deal with are the drunk type of cases, which I see more and more nowadays. And typically these drunk type of cases are your clubbing, post-clubbing sex, or post-party or during a party sex, right? Resistance, struggling is not always expected and should not always be expected in rape cases, right? So the lack thereof doesn't mean that if there is no resistance, it doesn't mean that the victim or alleged victim consented, but it will boil down to context in every case. So for example, we did a case some years back, the case of Ong Ming Wee. I'm not sure if you guys know of it. It's a post-Zook rape offense or alleged offense. We got the acquittal, yay. But in that case, contextually what happened was the victim or the complainant went to court and essentially said, oh, I was very scared of him. He threatened me. But when pushed further on what threats were said, she couldn't give any detail. When pushed further as to why she was scared, she also could not explain that. And on top of that, I think what layered on was the fact that she had several phone calls that she made and she received during the purported incident. There was therefore no, I mean, she agreed eventually that there was no resistance. But like I said, that in and of itself doesn't mean that she consented, right? One has to look at the other facts, which is she cannot explain why she was so scared. And because she also had the opportunity to take all these phone calls, and I think more importantly, the lack of corroboration in terms of her version of the phone calls vis-a-vis the recipient or the caller, that all put into question her credibility. And eventually the court essentially believed that there was consent, and if not, at the very least, there was a mistake of fact on the part of the accused person, in the sense that he honestly believed that she was consenting to the sex. if I can just segue into another case where it is another Zouk rape case, the case of Ong Soon Heng. That case again involved some level of intoxication, in fact, quite a bit. There was, thankfully for the prosecution and of course for the justice of the case, there was objective evidence in the form of CCTV footage from the club, which essentially showed how wasted the complainant was, to the extent that she had to be fireman lifted out of the club by the accused person. And he was supposed to send her home, but then in the middle of the journey, something happened, brought her back to his place, and then they had sex. And yeah. I mean, we're talking about both, right? Zouk, clubbing, both intoxicated. But in Ong Soon Heng's case, it resulted in a conviction. I mean, the guy absconded, supposed to go on appeal. I had nothing to do with him absconding. But yeah, I mean, so the point really is this, it eventually will boil down to facts and context. So I wouldn't be so quick as to say, oh, if there's resistance, it must have been rape, or if there is no resistance, it must have been consensual, right? Character. I think character of complainant often comes in when we talk about this type of cases where you go clubbing, and accused persons like to come to us and say, see, she wears that, she must have been wanting sex. So what David say really falls squarely with what we experience on the ground when accused persons come to us with that kind of information. But as lawyers, the duty is on us to advise as to that, whether it's relevant, if at all. And the way we deal with that approach or that aspect of things really is this. I agree, there is and should never be that stereotype where you say someone is scantily clad and therefore is asking for sex, and we're still asking to be raped, right? But where I think it can be relevant is in a very specific situation where a complainant comes to court and says something to the extent of, I was so traumatized by the incident that I don't go clubbing anymore, I don't go drinking anymore, and it's affected me so much, okay? But if I find information post-incident that can directly contradict this aspect of the victim's or complainant's testimony, then it is potentially relevant. But you see how that is not a stereotype. It is, again, very fact-specific, very context-based. So I wouldn't go so far as to say all social media posts that your client sends you is not going to be relevant. Sometimes it is, but it must be in a very specific situation where you can contradict the complainant's evidence. Okay? The fact that a complainant had gone through rape, feels traumatized, and still goes out partying in and of itself should never be taken to mean that she's not traumatized by the incident. Okay. Trauma also brings to mind another case we did where it is a gang rape. Well, not gang rape per se, because it was essentially 5 accused persons who took turns over the course of the night with the victim. At some points in time, the accused person did not actually know that sexual acts were being done on the victim. It was just a very bad night for her. Yeah. In that case, she was so drunk, the victim was so drunk that she could not actually remember most of the sexual acts that took place through the course of the night. She only remembered the last 2 acts which were committed in the wee hours of the morning. I think by then the alcohol effects were wearing off slightly and she could remember that. And it was on that basis that she actually made a complaint. So and we acted for the accused person who allegedly did something to her earlier that night, which she did not know of because she could not remember. So if I take that in isolation, there was no trauma per se because she didn't even know it happened, right? But can I say that just because she cannot remember, she didn't know of it, and she arguably did not suffer any trauma that she knew of in relation to the incident, does that mean that he did not force himself on her? No. In that case, I mean, what it boiled down to really is consent and whether she was in a position to even give consent because she was so intoxicated. And it resulted in convictions of all accused persons. The other type of category of cases that we deal with are your power dynamics, if you would, situations. So employer-employee. And I think in Singapore, what you often see is your employer v versus a domestic helper situation. I am happy to say that I'm quite satisfied that our courts don't carry with them these stereotypes, i.e., oh, just because it's an employer versus a domestic helper, it must be rape. Because we've experienced cases where acquittals have been obtained. We've also, of course, have had convictions, right? And what that really means, like David says, is that the system works. And thankfully for us, these types of stereotypes are not that pervasive, especially in amongst the judges. But one case that, just to illustrate, one case that we did some time back, not rape per se, but it was an outrage of modesty case, employer versus a domestic helper. There, like David said, where there is no objective evidence, and usually for cases of this nature, no objective evidence, it's he say, she say. So what the courts often have to do is they go into consistency, right? External consistencies, internal consistencies or inconsistencies of the victim's testimony. And in that case, because I think one big factor that the court decided that the court did not believe the victim was that the victim went so far as to say in her statements that her private part was touched. But in court, the complainant said, actually, no, it's only, my shorts. And I think that was jarring enough or material enough a difference amongst others for the court to then decide that, hey, I don't believe her. In another employer domestic helper situation we did a few years back, which resulted in a conviction, involved an employer who basically came home slightly intoxicated, got the attention of his helper, whom he had very, very little interaction with prior to the incident, to have sex with him. And then in the morning, he committed another sexual act on her. He says it's consensual. She says it's not. But what I think swayed the court as well is, number one, they had very little interaction. The court said there appeared no reason why she would say yes, which I thought was a little bit strange, to be honest. But I think the kicker for that case was in between the two sexual acts, she actually called a friend overseas to cry and said something to the extent of, my life is over, help me, right? And then subsequently, quite contemporaneously, she made a police report and the police came. The accused person's reaction when the police came was also something that I think was quite indicative of guilt in the court's mind, because he had knelt down immediately to say sorry to her in front of the police. And on this note, I guess, segue a little bit into how contemporaneous a police complaint is. Now, of course, as lawyers, it's a point that we often will ask, right? Why is there a delay in the complaint made? But again, in and of itself, it should not be determinative of whether a rape occurred or not. What is important is to understand and ask why and see if the explanation holds up. In Ong Ming Wee, so the Zook rape case, in that case that resulted in an acquittal, there was actually quite a contemporaneous police complaint made. So that on its own is not enough to say, oh, because you're so contemporaneous, it must have happened. The same will happen, as in should also apply in the reverse, which is if I take so long to make a police report, it may be because, like David said, I was trying to come to terms with what had happened, because sometimes you find that victims blame themselves. Victims question themselves to the extent that they are not sure at some point that, hey, maybe I allowed it to happen, maybe I consented, I don't know, right? But yeah, I do think that we need to be very aware as lawyers to not fall into the trap, I guess, of accused persons coming to you and saying, I want you to say this, because she's this. It's your job really to test the evidence of your client. It's also your job to advise your client as to relevance, which I think really comes at the forefront of everything. Stereotypes are not good, of course. But in those stereotypes, sometimes, maybe stereotypes is the wrong word to use, but sometimes certain things can become relevant for the purposes of pursuing your case. I wouldn't say it's a blanket, oh, she's scantily clad, therefore we should never use this in our cross-examination. It must be based on context, it must be a fact-specific inquiry that you make.
Okay, so there are some disagreements after all, although I suppose they will in terms of what the facts and evidence can mean in different situations. So we'll now have Dr. Chow Wei-Ling by her perspective.
Thanks. Thank you very much, Jacqueline. Thank you so much, David. So it's always a pleasure to be able to talk to people in practice, especially for us academics. I'll be talking largely about how gender bias is reflected, not necessarily in the sense that it may impact the judicial decision, but it's reflected in the language of the judicial decision. So gender bias, as our speakers have all highlighted, is a challenging problem, especially in rape and sexual assault cases that turn on assessing the testimony of the accused versus that of the victim. So my presentation is going to focus on gender bias in the context of rape adjudication. So when speaking about gender bias, it's important to note it includes a variety of assumptions and beliefs. Stereotypes, which are specific characteristics attributed to a group, such as women should be modest and demure. Prejudice, a negative attitude reflecting overall evaluation of a group. Stereotypes may lead to assumptions, such as if a woman is immodest, she invites sexual assault, or myths, such as most perpetrators of rapes are strangers. Such biases are problematic as they can influence the assessment of facts by decision makers. Even when such bias does not impact the actual finding, their reproduction and dissemination can be harmful. More so because most of this bias is implicit, which makes their identification and eradication very difficult. I suggest that more attention should be paid to the transformative commitment of the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, which Singapore ratified in 1995. CEDAW requires state actors, like courts, to not only avoid gender bias, but also work towards its eradication. Article 2F requires state parties to take all appropriate measures to modify or abolish laws, regulations, customs, and practices amounting to discrimination. Article 5A calls on state parties to change social and cultural patterns of conduct to eliminate prejudices and customary and all other practices based on the idea of inferiority or the superiority of either of the sexes or stereotyped roles for men and women. In other words, when you apply this duty to courts, not only should state actors like courts avoid relying on gender bias, they should take action within their powers to contribute to their elimination, which means also the reasoning and language used in judicial decisions. So due to their legal and social legitimacy, judicial decisions carry much weight. So first, courts should avoid such bias when deciding cases. Specifically, they should adopt trauma-informed and context-sensitive approaches, which are both speakers have actually addressed. And second, which I argue, courts can and should ensure that the decisions are reasoned in such a way that contributes to the longer-term eradication of gender bias, beyond deciding the individual case in front of them. So I won't repeat what the speakers have already talked about. So in terms of avoiding gender bias, I think that Singapore courts, especially in recent cases, have done a pretty good job. But I think that what they can do is really to articulate a trauma-informed and context-specific approach clearer. So for example, so Ong Ming Wee is an older case. So I think that the court, right, could have done more to recognize that trauma plays an impact on the complainant's behavior and reaction. So Diana has already very clearly set out the facts of the case. And so in some parts of the court's decision, the court found it that the court actually appeared frustrated with the complainant's behavior. So in this case, actually, both the complainant and the accused agreed that the complainant had been crying in the lead up towards the sexual act. And the court found that it was unable to understand why the complainant was afraid for her life, why she made no attempt to leave the flat, given the lack of physical restraint or threat of violence, and why did she not call the police itself? I think that the decision could have considered, assessed the fact that the complainant was in an unfamiliar place, may have frozen due to fear, and could have been disoriented due to alcohol. So I think that the decision could have given more discussion to these facts to emphasize how victims and complainants in different situations have reacted differently. So in terms of giving more attention to the context of sexual violence, I think power dynamics is really important. And courts can try better to pay attention to this, especially drawing on research, trauma and research. So for example, in the Singapore case of public prosecutor versus Wee Tiong Boo, which was also referred to by our speakers, and with this is without questioning the accuracy of the court's finding. It suggested that the Court of Appeal should have paid more attention to the doctor-patient context. So there is research showing that, especially for vaginal examinations, it's a very stressful situation for patients. So when questioned by defense counsel, the complainant, who had not had sexual intercourse before, explained that when she saw the accused penis partially in her vagina, had been confused and unsure about whether this was also part of the medical examination. The court found it difficult to understand how the complainant could have failed to appreciate that the accused's alleged actions was a violation of her person at the most horrific and abusive level, especially because the complainant was 23 years old at the time and pursuing tertiary education. The court went on to observe that it would have been the easiest thing for the complainant to have screamed for help, as there were others in the clinic. So sociological studies show that patients undergoing pelvic medical examinations often feel particularly vulnerable and exposed. Given this, it is plausible for a young adult to be disoriented and confused when sexually assaulted by a doctor in a supposedly safe environment, especially during the ordeal. Further, the court noted that the complainant had not told her mother about the rape, and this failure raises questions as to whether the rape occurred. I think that more consideration should be given that in Singapore's conservative society, most young women, regardless of education level and age, would hesitate to relate such incidents to their parents out of embarrassment and to avoid causing them distress. So this is, of course, not to question the eventual finding of the court, right? Because I think that it's important for courts in their decision to pay attention to how the reasoning is worded, to avoid reproducing certain assumptions and biases. So apart from drawing attention to the importance of trauma-sensitive and context-sensitive approaches, the CEDAW Committee has also emphasized the need for state actors to contribute to the long-term eradication of such biases. And CEDAW commentators have actually highlighted what courts can do, such as by clearly identifying and critiquing bias, elaborating on the meaning of consent, even when this may not be strictly necessary to decide the case. Singapore courts have indeed done so in certain cases, and more can be done along these lines. So in the case of Prem Nair and public prosecutor, this was a Zouk case. Is it Zouk? No, Sentosa beachfront Zouk out. Is it? Yeah. Yeah. Then, yeah, this shows how pathetic I am. Don't go clubbing. Yeah. So the accused had raped the victim, who he had met the first time in the club. And among others, the accused argued that he had in good faith mistaken the complainant's consent to such sexual activity because the complainant had been really flirtatious and friendly to him earlier in the evening. The Singapore Court of Appeal's decision set out a comprehensive definition of consent and rejected the accused's claims, emphasizing that even if the complainant had flirted with the accused, it could not be taken that she would have consented to digital or penal penetration later. The court could have gone further in these cases to identify and critique the problematic assumptions and stereotypes underlying these claims. Namely, consent to one type of activity cannot be taken as consent to sexual intercourse. I think that given the fact that there continues to be quite common misunderstandings of consent, some of the areas that the courts can undertake further elaboration in is this is also because I think the misconceptions of consent in an individual case is not usually restricted to the case alone and probably exists at a broader societal level. So judicial decisions pointing this out could play a pedagogical and expressive role. So one popular myth is that, as mentioned by my speakers, is that non-consent is largely expressed through the woman's physical resistance. But it should be noted that consent can be communicated verbally or non-verbally in an express or implied manner. A statement of no is enough to express non-consent. I think it would be helpful if courts can devote time in their judgment to condemn the popular gendered belief that when a woman says no, she does not really mean no. So it's worth noting that while courts play an important role in defining consent, the persistence of gender bias requires clear definitions of consent set out in law and policy. The civil society actors in Singapore have underscored that based on their work with survivors of sexual violence, poor understanding of the ground in consent is due in part to its negative definition and its negative consequences. Due to inaccurate understandings of consent, some survivors have not reported sexual activities. Further, civil society actors highlight cases where the police were not aware or did not make it clear to the survivor that physical submission does not mean consent. Because criminal justice actors and survivors usually refer to the Penal Code as opposed to case law. So I think that beyond talking about judicial decisions, I think we can talk about whether there needs to be comprehensive legislative action taken to maybe adopt a more positive definition of consent. Thank you.
Very much for speakers, and I think willing to raise a really important point about how the judicial reasoning itself needs to be quite careful about reading the complainant as well as how their own accounts are being portrayed. So we have some time now for question and answers. If anybody would like to start off, raise a hand. And so I do have some. Right, so we do have some time now for Q&A. We have some questions on Zoom itself, so perhaps I will start with these questions. The first question is, is there a significant impact of the stereotype against men being victims of sexual assault? And is it harder comparatively to prove that a man has been a victim of sexual assault? What does your experience say?
Stereotypes concerning men. You'll see that it is male victims are usually very reluctant to come forward, right? Mainly because they are afraid that they may not be believed, they may be ridiculed, right? The masculinity has been challenged, right? But that doesn't mean that there are no prosecutions where male victims are involved. So, talking about stereotypes, well, I personally did a case. Officer, police officer, a traffic police, a senior police officer was charged for arresting a few MS boys. Right at the trial below, the officer was convicted on all charges. Right, the most severe or serious charge is one where he sort of like brought the victim to his house and then instructing the victim to use a hair removal cream, right, to remove all the hair on his body because his colleagues complained that he had body odor. So on that, I'll just give you a few facts. While he was alone in the bathroom, the victim was alone in the bathroom, was applying the cream, and somehow the accused person managed to barge in, and then took over the application of the cream on his entire body, and that was where he just applied the body at all the sensitive areas, right? And at the trial below, he was convicted of the charge, but at the appeal, the High Court judge found that it is very difficult for him to see how a grown man, a 20-year-old boy, would not resist or struggle, and coupled with the fact that he was serving NS, right, the police force, that he cannot understand why he did not struggle or run away. So that charge was, he was acquitted of that charge. Okay, so yeah, so this is where you can see how the stereotypes thinking, right, applies. So, but there was on appeal. So that's the final stage of appeal, and that's it. So there's a very clear example, right? So, but he was convicted at the. So yeah. So one last comment. It is often that the victim or the victim of sexual assault, male victim of sexual assault, they themselves subscribe to these stereotypes. That make them very reluctant, right, to report the matter to the police. So you can see that. But when reports are made, rest assured the Attorney General's chambers will look at all the facts and then will then decide accordingly.
I've never dealt with any cases where the victim is male. Yeah. But I'm very assured that AGC always looks at everything. It's very hard, yes.
I think even the Penal Code recognizes the definition of rape is such that it can only be done by a man. Yeah. The code itself reflects certain assumptions about gender relations.
And that's where, your point about legislative changes might actually be needed to address more sort of modernized concerns. So on that basis, I hear, unless we have any questions, I do hear that there are, I'll let you ask us. Yes, go ahead.
There's overhead mics as well.
So, thank you for the speakers for your insight. So my first question is for Dr. Chia. So, Dr. Chia mentioned that courts should pay attention to how judicial holdings are worded so as not to promote certain biases and stereotypes, and that courts should elaborate more, or could elaborate more on the meaning of consent matter in cases. So then my question would be that, would a judicial definition of rape made in a court of appeal case contradict like the parliamentary intent behind having consent defined in the negative? Because it was mentioned in the PCRC report that this negative definition is de facto functional and simple. So if it was to be defined in the court of appeal, would it then contradict the code definition? And how would it?
I think the Court of Appeal in Prem Nair adopted quite a comprehensive definition of consent. And I think that it was discussed by the PCRC, the Penal Code Review Committee, that this judicial definition is very comprehensive and enough, and there was no need for a positive definition in the Penal Code. And I think that civil society actors, including AWARE, in their report stated that the problem with having positive definitions in judicial decisions, but not in the Penal Code, is that ordinary people, non-lawyers, will not go and look at case law. And if they look at the law, they will check the Penal Code. And the problem is, if it's not clear in the Penal Code what consent is, the survivor herself may be unsure as to whether she should make a report. And so this actually may discourage people from coming forward.
I just wanted to say, but I think you're right in that you premise the question on how it would be inconsistent, right, with Parliament's intent. Then I guess that's why Prof. Chia suggested that there be changes made to legislation. Yeah.
But do you find that the current jurisprudence or the current law on consent, right, insufficient to address the many issues that you have sort of raised? Insofar as a lot of times what I'm hearing is focusing on what the complainant said and what did the complainant do, and not so much on what the perpetrator did and what the perpetrator said. Right? So do you think that perhaps the balance in the law needs some rethinking?
I personally don't see an issue with that balance currently, because that balance is achieved with also placing the burden, and a very high burden, on the prosecution to prove positively that there was consent. But I think where
There was no.
that there was no consent. Yeah. But I think where I struggle a lot with is when we deal with a victim who was intoxicated and an accused person who was intoxicated. Then I think there seems to be an imbalance in terms of the obligations or what is expected of an intoxicated individual, right? So where it is an intoxicated victim, one says she is so intoxicated to the extent that she could not have given consent to a sexual act. But if I can just extrapolate that to cases of a different nature, accused persons who are intoxicated and, for example, assault drivers. And these accused persons sometimes really don't remember that even happening. But when that happens, that same level of could he have knowingly done that doesn't apply to him or her, the accused person, right? Not gender specific, of course. That's something I've always struggled with.
I have two comments regarding definition of consent. Right, let's say the Penal Code defines consent in a negative way. Right, there has been the definition of consent for many years. Even at the recent round of amendments, right, it was not changed. Right, it is still consent is not a consent. Right, if A and B. That's how it is defined. Now, personally, let me tell you, I've dealt with so many sexual offenses. It is not easy to define consent positively. There are so many variables that you have to take into account. There are so many things, right? If you say consent is A, B, C, D, right? If A, B, C, D happens, this is consent. But there could be E, F, G, H, all right? Or A, B, C, D happen, but it is in a different context. Or then is that consent or is that not consent? It is difficult, right, to have a positive definition of consent. Now, in a few cases, one of them is prejudice. The Court of Appeal specifically say, right, if she had, even if it was true that she was flirting, it doesn't mean that she wants, that she has agreed to sexual penetration. It's in a context. Is in a context. You must see that definition in a context. It is just like there's another quite good definition of consent. That is the case of it's prison officers, not prison officers, three prisoners assaulting another prisoner, right? And they claim that that victim consented, right, to being penetrated or being assaulted and all those things. But Justice Lee Yong Kwang, I believe, right, came up with a definition of consent for in the context, right? Because in the context of that case, because the victim was under threat, right, and pressure by the fellow inmates, right, and therefore he agreed, right? He agreed to be whacked, right, by the other accused persons. This is a sonic blastment or whatever. I don't know, the way they whack him is stand there against the wall and just whack. So they said that he consented to be whacked. But in what context, right, did he consent? Because if he did not let them do it, then the price that he had to pay each and every one of them. Things like this. Right? So they try to say that she consented. So consent in that context is not consent. Okay. So, but if you use it, if you try to analyze it in another situation, right, with another variety of facts, right, it may be consent. I don't know. So you cannot define consent so easily. That's number one. Yeah. Oh, yes, yes, yes. About intoxicated accused person. So far, I've not seen defense counsel entering reports on the state of mind of the accused person and say that the accused could not have done that because the accused didn't know what happened. But I've not seen any. If they want to
We try.
and then we see that then we will deal with it in court. So far I've not seen. It's always the prosecution who will tender psychiatrist report and say that the victim was in no state right, because of the level of intoxication. I've not seen defense counsel saying that, look, my client has this amount of alcohol in the blood and therefore could not have known that the victim didn't consent or whatever it is. I don't know what defense that they're going to run, but I've not seen such challenge. Yes.
We'll try. Thanks. Just go ahead.
But two related questions, I think, for Mr. Koo. I think the first, it's been a while, Mr. Koo. The first question is this, given the prevalence of stereotypes, and I think Chambers rigorously assesses the credibility of the complainant, alleged victim, before making a charging decision. And my question is this, given that most things will come with an explanation. When, why is there delayed reporting? There will be an explanation. Why do you not resist? There will be an explanation. Is there a concerted effort to see that, okay, there is this story, because it is a sexual offense, we are more likely to pursue prosecution because it is a sexual offense. We are just going to go for it, even though it's a word for word, no objective evidence. The threshold for meeting the evidential sufficiency test becomes lower, and Chambers is more likely to test the evidence in court rather than to apply a more rigorous examination internally. That's the first question. Second question is, in terms of stereotypes, do you see a stereotype or a concern relating to the education level of the complainant? Insofar as you are an educated woman, you are in this situation, could you not have gotten yourself out of it? As opposed to many times we see victims being children, very young people, or those who are in vulnerable positions, for example. And I think Dr. Chia had raised Wee Jong-bu, she's a tertiary student. How could you not have known that he was doing something to you? So does the education level of the woman unwittingly result in some stereotype that you ought to know, given your level, that you were into something? And does that play a role in experience, whether that exists?
If I may sort of add to that, because I think the education level also comes into play. It seems sometimes when it has to do with the alleged perpetrators' education level, potential in life and so on. So does that also, do you see that come in play as well? The three questions in total. And Diana, please go ahead. Feel free to.
On the first question, whether when we assess sexual offences, whether to prosecute sexual offences, we sort of like give a more lenient in assessing the threshold whether to prosecute or not. That's how I see it. That is a myth. Don't do that. You are from Attorney General's Chambers, you should know that. We don't do that, right? Just in fact, yes, we will seek explanations from the victim, right? When there's any loopholes in the case, so to speak, like late reporting, why you didn't shout and all those things. Yeah, we will definitely ask, because if I don't ask, defense counsel will ask if the case goes to court, right? And then the investigation officers would also ask. right? These type of questions. Okay, so after getting all the explanation, right, we have to do a holistic assessment of the case, right? We have to examine everything, the threshold of prosecution, sufficiency of evidence, right? And reasonable prospect of conviction is still applied, right? For sexual offenses, it's not lowered. Right, as you know, for prosecution, right, exercising of prosecutorial discretion, we have two thresholds to cross. One is there must be reasonable prospect of conviction and in the public interest to prosecute. Right, so when we assess whether there's a reasonable prospect of conviction, we look at sufficiency of evidence. And when we look at sufficiency of evidence, we will look at the explanation by the victim. We will look at what the accused has said in his police report, and what corroborative evidence that the investigating officer has managed to obtain, what the objective evidence. And then we have to look at it holistically and then make the decision, right? A difficult decision sometimes, right? Whether it is sufficient to charge him in court. In all sexual offenses, I think the second threshold is quite easy to cross, right? Which is, is it in the public interest to prosecute? In most cases, it is, right, in the public interest to prosecute. So it's the sufficiency of evidence. And rest assured, it is not lowered just because of these red myths or that we are very conscious not to take into account red myths, and therefore we lower standard. No. Second question, the level of education of women or even the accused person. You know, we expect them to behave in a manner or whatever. Not so much the level of education, but it is, you have to understand the victim, right? You have to understand, you must know the background, what are the experiences that she had gone through, right? And then you see her reaction, whether it is a reaction before, during, and after the rape, whether it is consistent with the level of the background, right? And then if it is not consistent, what's her explanation for it? Could it be because she froze when the right when the assault took place, right? A person can freeze, whether you are a PhD holder or whether you are a professor or whether you are a doctor or lawyer or whatever it is. It is, you know, it is very, very specific to the person, regardless of the education level, things like this. So still, this type of expectation, what we are looking for is we have to understand the victim, the background, what life experiences has she gone through, right? And then try to see the reaction, right, of the girl. I'll give you an example. Wee Tiong-gu, right? The girl didn't report the matter to the police. To the mother, right? We know that in the mother and daughter relationship, the daughter is the mother is the daughter. In that case, right? Their relationship is such that it's always the daughter is the victim who takes care of the mother. You understand? That explains why she didn't tell the mother, because she's the one who makes the decision. You know, we know all these things, right? Perhaps it was not brought up in court. I don't know, or whether it was brought up in court, but it explains. There is always an explanation if it has been asked, right? So it's like, yeah.
No, I was just wondering whether you've seen what's taken into account the educational background of the alleged perpetrator. You know, in the States, you know, in the standard case, what I saw that, well, you know, this guy has great potential, a whole life himself. We shouldn't, you know, ruin. You see that
even under the surface, where the life potential of
No, I don't see that. In our decision to charge, we don't do that. If you are talking about sentencing, right, that's another different ballgame altogether, right? You're talking about sentencing, how young, rehabilitation and all those things. That's another, you can take that into consideration. But in charging, so what, you are professor or whatever, or doctor, we have charged all these people before. We have seen it, a variety of people, right? Like even tomorrow, maybe a few more days, you see a few more people can be charged. Today, there's a professor, yeah, NUS professor charged in the papers. Right.
I think, I think what David said really again circles back to my point, which is that of relevance. An accused person for us as well, whether he is educated or not, really doesn't matter when it comes to claiming trial to a rape offense. He should and will be stripped away of all those attributes. And what is key really is establishing whether the act even took place in the first place, and if it did, whether there was consent or not. That really is all there is to it, if you're talking about a rape case, right, that goes to trial. Yeah. Victim. So whether the victim is educated or not, again, often I don't see that as being relevant, unless it's an issue of knowledge as to, for example, what to do. So for example, in a domestic helper situation, and this is not specific to rape offenses or sexual offenses, but when something happens to a domestic helper, does she know what to do, how to seek help, what number to call, for example? And in a hypothetical situation, if the victim comes to court to say, I didn't report because I didn't know what number to call, but we later established that this victim was equipped with the knowledge because she was trained before going to the employer's house, then we can use that information to contradict the victim's testimony. But otherwise, education in and of itself really should not matter as to why a person reacts in a certain manner or not.
Do you want to add on?
This is not a Singapore case. But in it's a very interesting Indian case, High Court of Delhi, 2017, Muhammad Faruqui. So this involved a victim who was very educated, PhD student. And Muhammad Faruqui, a well-known artist, had performed oral sex on the complainant despite her protests and was acquitted. In its judgment, the court set out its theory that instances of women behavior are not unknown when a feeble no may say yes, meaning yes. The theory will not apply when the parties are strangers and if the complainant is a conservative person who is not exposed to the various ways and systems of the world. However, the accused and victim were known to each other, are persons of letters, intellectually, academically proficient, and had physical contact. And in doing so, the court actually found that it's really difficult to decide whether little or no resistance of feeble no was consent, and it seemed like educated and worldly women who engaged in intimate activities by choice are expected to demonstrate higher levels of resistance. It's not a Singapore case, but just an instance of how educated levels did influence the court.
Really not Singapore case, right?
I think everyone is slightly outraged at this point.
We don't see this in Singapore.
Actually, that nicely sort of segues into a question online, which says, do all of you agree that actually much of legal reasoning in our court system relies on stereotypes? The idea of a reasonable, objective person, how would a reasonable, objective person act? And so, listening on to how, we're now trying to go beyond some of our sort of myths or stereotypes about how people will act in some of these cases. Should that change the way we present arguments or make decisions in the court of law?
Maybe I can start. I think that reasonable or objective standard applies and should continue to apply in certain type of cases and offences. But in the context of sexual offences that hasn't, in the 10 years I've practiced, been applied. It's a subjective test. It's a very fact-specific inquiry that the courts undertake. Yeah, and I think that's the correct approach.
I agree with Diana on this. Right. Yes, it's a reasonable, objective person has, but reasonable, objective person in the context of the facts of the case. Not reasonable person on MRT, you know, is in the context, knowing very well, you know, all these different types of, for example, different types of reaction to trauma, you know, knowing very well informed, you're trauma informed and all those. So a reasonable person in that context, right? You use that standard. Yeah, I think so.
I think that this is a very interesting question. I think that because of the way consent is defined, right? It comes to, if consent is negated by fear of injury or misconception of fact, the accused person can argue that I did not know, right? Or I should not have known that there was under misconception or fear of injury. Then when it comes to incapacitation, the accused person, and in fact to all, the accused person could argue defense of mistake. And that's where good faith standard comes in, so reasonableness standard. Right? And this was actually successful and ongoing also as an alternative decision, alternative ground of decision. What is really interesting is whenever I discuss these cases in class, when we start talking about defense of mistake, whether you put yourself in the position of the accused, would you have made a mistake given all the facts of the case? There are grounds for this agreement. Some will say clearly, given all the facts of the case, he had made a mistake. Some would say that clearly, given all the facts of the case, come on, how can you have made a mistake? And I think because consent is communicative, it's interpretive. And I think that if we want to establish certain standards of what consent is, there needs to be definitely more discussion of what consent is so there can be less misunderstanding, a potential misunderstanding of what this communicative or interpretive act is.
Will all be very clear if you always ask and you always answer. And, you know, there's little room for interpretation.
And I think I think it's important to really drive home the point that no means no. People have to stop saying, oh, that feeble no actually means yes. Okay, so yeah.
So when we discussed this also in class, our social practices on the ground don't reflect that currently. Like you engage in sexual activity, current social practices, what we're exposed to in media, doesn't require you to ask no at every stage, right? And so I think that there definitely needs to be, beyond the law, more education and on the ground on what it means to be giving active consent and seeking active consent.
I want to Diana said no means no. Another thing which I want to drive home is yes yesterday doesn't mean yes today. Yes last week doesn't mean yes today. Right? So this is also another message.
We have very little time left. We did start slightly late. So I'm going to sort of take 2 more minutes to ask our panelists sort of a wrap-up question, which is that we do see in these cases some disagreement across the courts, right? You know, the trial court may convict, and then, you know, the upper court acquits and so on. I wonder if you think that some of these sort of disagreements across the courts might be resolved, for instance, by having a specialized court, a court that is with judges specialized in sexual crime, sexual offenses, and who are trauma sort of trained and you know, able to see some of these issues that we are addressing today in a much clearer fashion, because that's where they're coming from. Do you think that that is something that perhaps Singapore should be looking at, having specialized sex crimes courts?
Let me think. Yeah, what I'm going to express is my own personal opinion.
Not an institution.
Not an AGC. Yeah, I am aware that in some countries there are specialized courts, but dealing with sexual offences in New Zealand. I think Malaysia too, right? They have started. I don't know what's the experience in Malaysia. I've not seen any reports, but in New Zealand, apparently there are positive reports coming out from there, right? Well, Singapore may choose to go that way, but a lot of things that have to be considered: resources, right? Training, resources, a lot of policy considerations, right? Of course, there'll be pros, right? We can get a lot of benefit if the judges are specially trained, they're trauma informed, and also how to deal with children, because more and more that we see child victims, and how children is another different group altogether, and how we deal with child evidence, right? So yeah, so if they're trained in that, then okay. But another way of dealing with this, I also thought is we can get experts to testify before the courts, right, in certain deserving cases, and explain to the court the actions or reactions of the victim, right, of the particular case, and whether what does the research show, right, and they can share with the courts. We have done that in a few cases, whether at the trial or even at the appeal stage. We have produced expert reports, but to expect this for every case, I think is impossible. We have finite resources. Then our healthcare, our mental health care professionals are also very swamped. There are lots of work for them. Imagine, in every sexual assault case, you have to produce an expert. That is not feasible, right? But in appropriate cases, we will do so. Also, really, another way is education, engaging IMH, psychiatrists, MSF, psychologists, right, to give talks. In fact, this is ongoing, right? They have done that for police officers and DPPs. And through the Judicial College, I also understand, through the Judicial College, they also give talks to the judges, right? And share their research or overseas research on how victims usually behave, things like this. Yeah.
I think at first glance, or me first hearing about this, it sounds like a good idea, but I question whether having too much training puts judges in a particular place of perception, right? Because I'm so equipped with particular literature or type of training that I come in, hear a case, and I already come to it with some preconceived notion of trauma. But the second point I want to make is, as much as it's important to make judges understand trauma and all the other issues relating to rape offences, I think equally important is the training of the different stakeholders, including lawyers, which I think we are often sadly forgotten. The training David talks about, we don't get to go. But yeah, we're not learning. But I think what can be done better really is to educate and train stakeholders, because we all play a part in this system. It's not just the judges making decisions in vacuum. right? We assist the court, and it's how we assist the court that matters as well.
No, I think that when it comes to gender bias, I think that it's relevant not only we've talked about it in the context of rape and sexual assault cases, but I think that this is training that everyone can do, and it applies to other cases also. So we have some provocation cases where the court actually notes that, the victim was dressed this way, and this also explains why the accused was provoked. So I think that gender bias is something that refraining from reproducing these biases is a concern that goes across all areas of the law.
So, of course, there are finite resources, but we can obviously all do our part to sort of move the needle along. So, well, I hope that you have all learned from today's discussion as much as I have. And would you please join me in thanking our speaker? Thank you very much to all of you for being here. So the session is over. Thank you.